Thanks very much for joining us tonight. I do hope this can be of value to everybody who's present. I find whenever I do these things, invariably, there are a lot of questions that come up more so to the end. And often when we're doing it in person, it's people kind of come up to me after the fact and they sort of have a question. So I don't want to be, I know it's a bit unusual in terms of the format, although everybody's probably used to it at this point in time. But if you have a question, just feel free to either put it in the chat or you can unmute yourself and interrupt or interject, and we can address any question directly. You should feel like you have complete access to me to ask any questions that you want. What I'm going to try and do is just to give an overview about the kind of work that I do and that lawyers do in this area of law, which is, personal injury law broadly. And just a little bit of an introduction about myself. So you might know I've been a board member of the Brain Injury Association of Waterloo-Wellington for some time, and I grew up in Waterloo. My parents still live there. I still get back there quite a bit. I have lots and lots of friends there that I'm connecting these days a lot on WhatsApp as opposed to in person. I know many of you are from not just Waterloo, but the much broader area that the Brain Injury Association services. And I hope that you've found that we've been able to continue to assist you through the pandemic in some way. And if you have, again, if there's anything that we're not doing that we should be doing, please, again, let us know either by email or through the various social media platforms that we run, or you can put it in the chat and I'll take it up with the rest of the board, and we'll do what we can to build that into the programming. So in my role, I'm a partner of McLeish Orlando. McLeish Orlando is a law firm that practices personal injury law throughout Canada. We've been very fortunate to have some good success on behalf of the plaintiffs that we act for. We only act for plaintiffs, meaning we only act for injured people. So if you're not familiar with a lawsuit in general, there's two sides, of course, as is typical in legal dramas, and we only act for injured people. I've been doing this kind of work for just over a decade now. I became interested in this area of work at the conclusion of my law school. Actually, I had a family member who was fatally injured actually in a workplace accident, and so this became something that I felt I could apply my legal education to in a meaningful fashion. And lo and behold, here I am over a decade later at the same firm, really enjoying working for the people that we do and the people that we assist on a daily basis. And I really do approach the practice on the basis that it's personal work that we do. So it's called personal injury, but we really do act for individuals, almost all of which who are there through no fault of their own. And typically this is the first interaction that they've had to have with the legal system in Ontario, as far as what we call broadly the law of negligence. So I did put together a little deck of slides. Just I thought it might be helpful. Sometimes people find it helpful just to have a few keywords as I'm talking. Other people find it distracting. So I'm going to try and share my screen. So the slide you should see first is when to call a lawyer, and no surprise here, immediately when. So what I recommend is that if you have sustained any kind of injury, however that might have been caused, you should call a lawyer immediately. Most people that we speak with have a lot of consternation about speaking with a lawyer at an early stage. And the reasons, there's a number of different reasons that they may be hesitant to talk to a lawyer. What I find the most common reason that we hear about why people avoid calling a lawyer is because of the potential costs associated with that. So as with virtually every other lawyer who practices, it is an area of law where you can obtain a consultation with a lawyer. And virtually everybody who does this kind of work well in Ontario will either sit down with you and meet with you in person, speak with you over the phone, speak with you by Zoom in this format, and talk about the legal issue that you have, and talk about whether or not that they can assist you. And they'll do so without sending you a bill, either now or in the future. And I've had consultations, initial consultations with people that have lasted quite literally hours, going through the legal issue that they may have, and then giving them some advice as to whether or not I think it's an issue that they can assist with. And we would, of course, never send you a bill, and there's no obligation to to move forward. Some people worry about that too. Well, if I take an hour of your time, then I'm already sort of bound to accept a retainer with you and with your law firm. And that's really not the case at all at our firm, and it shouldn't be the case with any lawyer that you meet if you have a need to do so because you've been injured. We say at our firm that it's very, very important that you find a good fit with your lawyer, and that goes both ways. We need to have a good working relationship with our client, and you need to feel comfortable that you're getting the right advice. And the process is going to take some time. So I see there's some comments popping up in the chat. I'm just going to take a look at that, and hopefully I can come back.
Joe, do you want me to read them out to you? It's Mara.
Oh, thanks, Mara. That'd be great.
Just in case, for the technology's sake.
Yeah, I appreciate that.
So there was a question from John, and it says, if you are injured on the job site, can the employer lay you off on the same day?
Well, I guess the employer can do pretty much anything that they want. The question is it legal if they laid you off on the same day? And the answer to that question would have to do with a whole number of different factors. It would have to do with whether or not, well, first of all, it would have to do with how long you've been in the employ at the work site, and then we would have to look at a number of different factors. But yeah, employers can and sometimes do make the decision to have somebody simply go home if there is an accident. As to whether or not that's would be a legal, would usually follow the specific facts of that case.
There's one more question,
Mara, that you don't mind reading to me?
Yep. There's one more question here, and it's, can you use a lawyer to help with an incorrect IME?
Sure you can. So let me answer that question by I'm going to take people through into that area that I was going to discuss, which is why. Well, why you should retain a lawyer is because your lawyer will help you in your recovery. So how do lawyers help you with your recovery? Quite simply, at the end of the day, you hire a lawyer because you are trying to have some financial assistance with the difficulties that you are encountering as a result of the injuries that you've sustained. In certain types of claims, you will actually have access not simply to a financial recovery, but you'll have access to recovery in the form of benefits that will be available to you on a more immediate basis. Okay, so there's many types of claims that we work with throughout the country and in the province of Ontario predominantly. Most people who contact us about injuries that they've sustained in a motor vehicle accident. And that's just because statistically, that's where the predominance of people get injured is in a motor vehicle accident. And a motor vehicle claim in Ontario has some specific features to it that other claims in Ontario do not. So the kinds of claims that we work on at McLeish Orlando are claims arising from injuries through a motor vehicle accident, claims arising from injuries as a result of professional negligence. So these are things like medical malpractice. It could be another type of professional who's not necessarily a physician, but who has not met the appropriate level of professionalism, what we call the standard of care in that industry. It could be a claim against a manufacturer of a device that's working improperly. We also act for people who have illnesses, not injuries, who are making claims for various benefits. So if you're denied for a short-term disability benefit or a long-term disability benefit, if you have there are many different benefits where you have to meet a certain definition in order for insurance company to pay a benefit to you, and we work on all those types of claims. That could be maybe you have mortgage protection insurance in your house that is only available if you have a particular type of illness. So we deal with those types of insurance denials as well. We also do act for a number of people who've been injured as a result of sporting type of injuries. So long and short of it is lots of different types of claims. You may think that you've been injured as a result of, just what we call them accidents. But what we typically find is that, a lot of injuries occur as a result of preventable conditions, what we call, negligence. So somebody falling below a legal standard. And in those types of situations, you have a right to make a claim in Ontario through a system that's called tort law or the law of negligence. And the question that I also often get when we first speak with people is this one: who pays, right? So just as there are multiple types of claims, the way that people get injured, there are also these multiple systems in Ontario. So one of them, the most predominant one again, where people get injured in Ontario is the motor vehicle system. And the motor vehicle system is a unique entity unto itself. So if you're a driver in Ontario, you carry some form of insurance, or you certainly should. Most people do. And that provides you both with insurance that protects you in the case of an accident, but also provides protection if you happen to injure somebody in an accident. And a lot of people don't even recognize that they have what's called no-fault coverage or accident benefits coverage when they're purchasing insurance. What most people focus on is the amount of third-party liability insurance that they're purchasing, either through their vehicle insurance or through a homeowner's insurance policy. And that type of insurance protection is a protection that provides you with coverage if you injure somebody else. And in Ontario, most drivers carry $1 million of insurance. If you spoke to your broker, they'd probably tell you that it costs somewhere between $10 to $40 to double that coverage, and most people aren't aware of that. And that also provides you with an additional level of coverage if somebody injures you and they're not insured sufficiently themselves. So this is a sort of, if you're making a checklist and you want to sort of do your insurance homework, this is a good thing to check on. How much third-party liability insurance do I have? And what does that mean in terms of my own family protection coverage, which is a particular type of insurance coverage that's available through your own auto insurance policy. And again, it's the one that gives you coverage if you're injured by somebody else and they're insufficiently insured. So that's one where if it only costs a few dollars extra to pay for it, that's one that I say is certainly well worth it. So if you're injured in an automobile accident, and now I'm slowly making my way to the question that somebody had asked about an IME, which for those who don't know is a short form for an insurance medical examination. So in the auto insurance system in Canada, in Ontario, what we have is a two-stage system. On the one hand, we have the no-fault accident benefits system that's governed through what is now called the License Appeal Tribunal. And on the other hand, we have the tort system or the lawsuit system, which is governed through the Superior Court of Justice in Ontario. So the License Appeal Tribunal is essentially a simplified form of a court setting. So the idea when the government mandated that disputes through your accident benefits insurer go through a tribunal was to try and streamline the process. So there's the idea that the government had was there's a long wait to get before a court. Going through a court is expensive. You may have to retain a lawyer, although you can't act for yourself. So the idea was to create a more simplified system that has some but not all of the rules of court. And so injured people could pursue their no-fault claims through that system if they have a dispute with their insurance company themselves. And it's a little more complicated than that, but I'm going to get into it. So that's system one. So the no-fault system goes through an arbitration system. No judges, just arbitrators who ultimately make decisions. And then on the other side, you have the tort system, which is in Ontario goes through the Superior Court of Justice system. And you would expect that if you're injured in any way, you would need to have your case proceed through the Superior Court of Justice in most cases. So another question that I often get in terms of when I'm meeting with clients initially, and they are talking to us about their situation, I often hear, is this something that's worth pursuing, right? So I've been injured, but I've had some time away from work. I was able, maybe they've been treated through the hospital system. They feel that they've been able to get the care and attention that they need, and they want to know, is this worth pursuing? Ultimately, as I said earlier, this comes down to a question of answering this question comes down to what is at the end of the road. So your case will take some time. So whenever people are injured in the province of Ontario, the most significant feature that limits or constrains how long a case will take has to do with you, with the injured person, and how your recovery is going. So typically, in terms of the work that we do, and many of you may be familiar with this as well too. If you have an injury, usually you have a period of acute care where you might be in the hospital, and then you're discharged, or you go to a rehab facility, and then after that you may be meeting more with community people. You go to see your physiotherapist, maybe you go to see a speech language pathologist. There's all different kinds of rehabilitation, of course. And as you go from a hospital setting back to your home setting, maybe you're returning to work, the hope is that, of course, you're improving. And ideally, if people are injured, they would have a complete recovery and they wouldn't have any ongoing limitations. Sometimes it takes a long time to know if you're going to have ongoing limitations. Sometimes because of the extent of the injury from day one, what the extent of the injury may be. Now, in terms of brain injury in particular, what we find is that it's often not the case that right away. So we meet with lots and lots of people who have limitations early on in their case, but they've been able to get back to work. Maybe they just have some lingering cognitive deficits, or they just don't feel as as sharp as they were before in terms of their ability to do the work that they did on a daily basis. Maybe they're able to do the work, but then get home and they're frustrated, or they have more anxiety, or they're shorter with their family members. So there are these kind of lingering issues in the background, and people can't identify. It's not like there's a picture of a broken bone that their doctor has told them, you have an injury that is clear in your skeletal system. And because we're still just learning a lot about the science of brain injury, this is often the case in terms of brain injury. If you have a very severe traumatic brain injury, it's very easy to diagnose. There are pictures, there's different diagnostic tests, and we can see what parts of the brain are injured. But when it comes to more minor or less severe traumatic brain injury, the science is still evolving. We don't imaging tests that show us with the level of specificity that we do when it comes to really, really severe injury. So it's not always immediately apparent that somebody sustained a brain injury. And then complicating that, and I don't need to tell you, I'm sure lots of you are aware of this, but it's often the case that because of how a person appears, that maybe they're just seeing their family physician. Their family physician isn't familiar with mild traumatic brain injury or moderate traumatic brain injury, and they just say, well, there might be something here, but it's not really my specialty, and you kind of get brushed to the side. Or maybe you don't get referred to somebody who has an interest in trying to figure out what's going on with you. And so it can take quite some time even to have a diagnosis in many cases. Those are all factors that contribute to how long a case takes. One is diagnosis. So do we know how you've been injured and where that injury has occurred? And then the second has to do with how your recovery has gone. So again, if you have initially you have some recovery, but then you sort of hit a plateau, we want to know then, okay, well, are things going to pick up and you're going to have more recovery again, or are you plateaued? In other words, let's say you get back to work part-time, is that going to be the case for the rest of your life? Or is there something that we could do to change things so that you can get back to work 100% of the time? And typically in cases, what we hear from the experts that we work with in the medical health field is that it takes about 18 months until physicians and different practitioners and rehab professionals can say with some degree of certainty what an injured person's prognosis is. Why I say this will take some time. In most cases, it takes about that 18-month mark just to see how you're going to recover and what level of residual limitations you're going to have. So going back again, so why do you need a lawyer? Well, in terms of an accident benefits case, or the no-fault case, it's true that, if you made a claim to your insurance company, they likely told you, it is a paper-intensive process, but you don't need a lawyer. You can submit claims for benefits without the assistance of a lawyer, and that is all true. In fact, if you have a good adjuster, and there are lots and lots of good insurance professionals and adjusters out there who will give you good advice and make connections with the right people so that they're helping you to recover. It is your insurance company after all. they may make it fairly easy for you to access these no-fault benefits, which fall into 3 categories: the minor injury guideline, the non-catastrophic category, or the catastrophic category. And they may do a good job of explaining to you what sort of benefits you can apply to, and they may connect you with good community rehab people. But ultimately, they control the flow of payment from the insurance company to you. And so sometimes those insurance adjusters have an interest in, not necessarily not sharing the information with you, just they may not be as diligent in terms of making sure that you have access to those funds as a lawyer who's advocating for you would. So when it comes to an accident benefits claim, we recommend that you have the assistance of a lawyer. And at our office, we don't charge anything in terms of assisting with the accident benefits claim. The idea is, look, it's a new system. Nobody, when they're injured, needs to try and learn a system of insurance benefits and how to apply for them. So what you should be doing is focusing on your recovery, not trying to sort out what benefits you're entitled to and how to access them. And the other reason that we assist with accident benefits claim is because there is an interface with the at-fault system. So the benefits that you're entitled to through your no-fault system are part of the recovery that you get in an automotive claim for negligence in Ontario, but they're not the whole story. So some benefits come from your own insurance company, and that's managed through the system of no-fault accident benefits, which, if you have a dispute with your accident benefits insurer, will go over to the licensing appeal tribunal, the arbitration system that we talked about. And the other part of your compensation, the less immediate compensation, comes from your lawyer starting a claim in negligence. And what starts that is your lawyer issuing what's called a statement of claim. So in the accident benefits side of things in Ontario, you notify your own insurance company. Maybe it's Aviva, maybe it's Intact. These days, a lot of people are insured with Intact, and then you begin the process of being able to ask your insurance company to fund treatment that is required, reasonable and necessary as far as your recovery goes. So physiotherapy, like we talked about, that might be one example. And the idea is that, with the access to those funds early on, hopefully you can have the treatment that you need to reach the level of recovery so that you don't need to have an at-fault claim or a tort claim. But if you hire a lawyer and you're having difficulties, maybe you have had some therapy through the accident benefit system, but you haven't got the recovery that you feel you should have. You're not back to work 100% of the time. You're not doing the things you did outside of work the way that you did. Maybe you're not playing sports. Maybe you don't go see your friends and family as often as you did. That's where you want to speak to a lawyer and talk about what you might be doing through the at-fault system. So this is maybe a good time for me just to pause, and if there's any questions that it might be more helpful for me to address now as opposed to waiting to the end, I'm happy to do that. I know that sometimes it's helpful to have them answered while I'm talking as opposed to at the end. What do you think, Mara?
We'll give you a little break, Joe. There's a few that have come in, so I'm going to start at the top. Give me a second.
Okay.
So the next question was, do you have 2 years to initiate a lawsuit, or can you take longer than that?
Good, very good question. So the default position is you have 2 years from the date of your injury to start a claim. That's a very baseline standard. it's a little bit more complicated and a lot than that, but that's what all the lawyers will tell you is the safest way. You start your claim within 2 years from the date you suffered the injury, you're all set, and the defense lawyer and their client can't say you were too late in bringing your claim. So there are certain exceptions to this. The 2-year limitation is set out in an act called the Limitations Act, which is legislation in Ontario, but that's generally the case. As with almost everything else, there's exceptions to every rule. So there are, let's say you've had an injury and you haven't talked to a lawyer. Now I'm really jumping ahead of my chat, but anyway, you get to the point. So when I said call your lawyer immediately, what happens if you haven't called your lawyer immediately? Just call them when you have questions, because there are lots of situations where the 2-year limitation may be extended. The first, the easiest example that you may not be familiar with is right now. So we're currently at the start of the pandemic in March in 2020. The court system issued what's called a suspension on the expiry of the limitations period. So that has had an effect of lengthening the amount of time that you can start a claim, longer than you ordinarily would have been able to. So that's one exception. There are many others. Minors, so anybody who is a child, so under the age of 18 in Ontario, that 2-year period doesn't start to run until they're age 18. So I acted for a client one time. His parents had, not pursued anything. They felt through his high school years that he was really struggling. No one was really able to identify this. And there was a neuropsychologist who said, well, wait a minute, there was a car accident a long, long time ago. And this is very likely related to that car accident and the injuries that you sustained in it. And so we were able to act for that individual, despite the fact that it had been over a decade since their accident. There are other exceptions to the 2-year limitation period dealing with severity of your injury as a result of the definition of what suffices to meet something called the threshold for claims in Ontario. So there are lots of exceptions to the 2-year time period. It's important always, even if you think you've passed something, to speak with a lawyer. And the other really important thing to know about is that's the limitations that apply in Ontario. Many people are injured in different states, in different provinces, and the timeline in order to advance a claim may change dramatically depending on the location where you were injured. Hopefully, whoever asked that question, that answers it. But if you have any follow-up, I'm happy to go through that.
There's a few more questions here, Joe. So the next one is, how successful is mediation?
So mediation is very successful overall in my experience. The success of mediation depends an awful lot on whether or not the pieces of the puzzle, as I'm going to call them, are in place. So when we get to a mediation, if you're, again, for people who may not be familiar with this, so a mediation in terms of litigation in Ontario, except in 3 jurisdictions, is a optional process. So in Toronto, in Windsor, in Ottawa, you must mediate at some point in time if you have an at-fault claim. Everywhere else, it's optional. Now, we, in our practice, we propose mediation in every single case. We think it's a good opportunity for the parties to get together and to talk about the claim with a third party, the mediator, who's usually a very experienced senior lawyer, but who doesn't have a stake in the case. So, a good mediator may tell me, well, Joe, I understand this is the position you're taking on behalf of your client, but have you thought about this aspect of it? Or are you really taking into consideration what a jury or a judge may think about this particular aspect of the case? They're going to challenge the basis that we're assessing a case on. Good mediators call that reality testing. So is this a legal position that you've staked your claim on, or is it something that you are assessing correctly in terms of what the outcome might be at a trial? And I say mediation is generally can be very successful because when properly prepared for a mediation, you are in the position that you otherwise would be in if your trial were to start tomorrow. Okay, so often it's not the case that you're mediating the day before your trial starts. It happens earlier on in the case. And the way that we prepare cases at our firm is we would only attend a mediation at a point when, one, you've reached a level of recovery such that we have an understanding about what your prognosis is, meaning you've kind of reached that 18-month mark, maybe 24-month mark, and we've talked to your medical team, we've talked to the experts, we understand what's the rest of the trajectory going to be like. So we know what your needs are. We know if you're going to be able to get back to work. We may not know definitively, no one's got a crystal ball, but we have the expert opinion that we can rely on to say whether or not those things are going to be possible, so we can assess your case. We know about the liability facts. So we've talked to witnesses, we've talked to engineers, we've been in a position where we have a sense of what the evidence is going to be about how the injury occurred, so that we can assess how a juror or a judge might decide who's responsible. And if those things are present, then you have a good opportunity to have a meaningful mediation, because everybody is essentially ready to go, prepared. Everybody knows the other side of the case. And interestingly, in Ontario, the rules of court are actually designed, generally speaking, to encourage settlement. So, people sort of have this perception that maybe because it's much more dramatic, or maybe because of legal dramas, that it's a trial by ambush, and you only find out things at the last second. But in fact, the rules of court in Ontario force us to share the information that we have when we obtain it with the other side. So if anyone plays any kind of card game, it's as if you were playing a card game where you're dealing the cards face up, and you're playing, everyone's playing, seeing the hand that others have dealt. Now there's certain exceptions to that, but that's the way the Ontario rules are designed. The idea is, if you have something that affects the case, share it with the other party so that they know, let's try and keep these cases out of court, because it takes a long time to get to the trial. And that is the single largest feature that affects the outcome of a mediation, in my opinion. So what we've seen recently is, because there was a lot of uncertainty because of the court shutdown initially, insurance companies were coming to a mediation and they were making offers, but suddenly the offers were out of the range in terms of what we had been used to seeing at a mediation. So mediation needs to be able, we need to be able to say, if we cannot resolve this case, we are prepared to move on to the next stage, which is a pretrial conference in a tort claim, or it might be an arbitration if your mediation is relating to your no-fault claim, or both. And then you're ready to move on with a trial. And ideally, that trial date is sometime within 6 to 12 months following a mediation. Because of COVID, those timelines have been pushed out a little bit, and that has been able to affect the outcome of mediation. But generally speaking, a very good success with mediations, and I do feel that they're an important and valuable tool in terms of proceeding with your case. Your lawyer should be doing them, or considering them at the very least.
Joe, we have a few more questions that have come in. I'm just wondering, from a time perspective, we have about a half an hour, 35 minutes left. Do you want to jump back into your presentation, or do you want to cover some of the presentation with these questions?
I'll cover it with these questions. So some of it, I mean, I have I have some more slides left, but they're not, again, I'm sort of treating this as it's more important that I answer your questions. So let's do that, and
Perfect. I thought so.
move through the other slides quickly.
Awesome. So the next question is, if the person at fault that caused the accident has a suspended driver's license and was driving her mother's vehicle, and the mom says she didn't give her daughter permission to take the car, however, was not charged with theft, how does that affect their insurance liability?
Yeah, so that goes to an issue called consent. So ultimately, the contract of insurance that you have with your auto insurer is just that. It's a contract. You have to live by certain obligations, and if you do, then the insurance company will provide you with coverage. And because auto insurance in Ontario is what's called a creature of statute, so it's legislation, there are certain rules that you must meet under the standard auto insurance policy in the province for the insurer to provide coverage. So in this circumstance, what you would need to know is, you would need to know all of the facts surrounding how the daughter came to be driving that vehicle. And it's one thing for the insurance company to say, look, we're taking what's called an off-coverage position. In other words, you violated a term of our policy, therefore we don't have to pay. But they have an obligation to show that those conditions were met. Right? So, often we see cases where an insurance company is taking the position that they do not have an obligation to pay because one of these conditions is met. An unlicensed driver, takes a car from a residence, but nobody gave them permission to do so. But then we dig a little deeper and we find out, well, the unlicensed driver had their own set of keys to the vehicle. And so even if they didn't get consent on that night, well, they had access to the keys, which means maybe they had implied consent. So the answer to your question is you must look at all of the individual facts in that particular case to see if there is a coverage violation or not. So if there's a consent issue or not. And it may be that there is, in which case the insurance company would only have to respond with what's called the minimum limits, statutory limits under the policy, which are $200,000, or it may be the case that they don't have to provide any coverage, depending on the extent of the insurance breach. In either of those two cases, excuse me, if you have your own auto policy and you're the injured party who's injured by somebody who isn't covered by insurance, this is again where you would then turn to your own auto insurance provider, and you can then direct a claim against your own auto insurance provider for underinsured or uninsured coverage. This is that family protection endorsement that I talked about. So again, if you're faced with that situation, it's very important that your lawyer would, do that kind of investigation and determine if it's necessary to start a claim to sue your own insurance provider.
Great. The next question, I think you touched upon it a little bit, but it is, what are the pros and cons of trial versus mediation?
Yeah, so pros and cons of trial versus mediation. If you go to mediation, I'm gonna borrow from a lot of the good mediators' speeches that we work with. The biggest factor that's different at a mediation versus at a trial is who the decision maker is. And if you've been part of a mediation, or you will be part of a mediation, you're going to hear the mediator say, "This is your opportunity today to be the decision maker in your case." And they would usually say something along the lines of, if your case proceeds to a trial, it'll either be decided by a judge, or if the defendants have served what's called a jury notice, it's going to be decided by six people. And that's six strangers that you don't know, you've never met, and you know very little about. Maybe you know their name, maybe you know their occupation. That's about it. So you don't know what they bring to the table. You don't know what's going to inform the decisions that they make. And that makes it really difficult to determine how they may decide your case. Are they going to believe that you've sustained an injury that they can't see on a picture, if it's a mild or moderate traumatic brain injury? Are they going to believe that, you can't return to work, or are they going to think, well, maybe they just made a decision not to work, and this person is using the injury as an excuse not to go back to work. And so those factors, that who is the decision maker, is the biggest feature that's different in a trial and a mediation. And the mediation allows you to assess, is the offer that I'm getting sufficient in light of the risks that I would otherwise take of going ahead with a trial? And a good lawyer at a mediation should be prepared, as I said, like prepared to go to trial the next day if the mediation is unsuccessful, even though that's not when it's going to happen, because that allows the lawyer to be in a position to say, this is not a reasonable offer. I don't, based on my experience, based on what we see judges doing, based on the case law that's emerging, I think you're going to have a different outcome than what this offer represents in terms of what the outcome will be. So that's the biggest difference about a mediation. The second biggest difference is the amount of time it takes. So a mediation typically is set aside for a day. For really complicated cases, sometimes we have multiple days set aside, but almost invariably mediations are a day long. And a trial is going to be much longer. So, a typical personal injury trial is going to last anywhere from 10 days to literally at the longest trials that we do are sometimes months. So, that is a factor that people worry about at mediation. Virtually every client I work for doesn't want to be part of a trial and would like to avoid it. And I can understand why. Trials are anxiety producing, and you do worry about what the outcome may be. No one can predict what these 6 strangers are going to do on a jury, right? It's like if you pick your favorite coffee shop in wherever you live, and pick 6 people out of that coffee shop, and those are the 6 people who are making the decision about your life, something very, very, very important and intimate to you. And so it's hard to entrust that to strangers. So what I tell my clients is trial is a long way away. Mediation is an opportunity to settle your case. It's a very good opportunity to settle your case, but it's by no means the only opportunity to settle your case. And what people should be aware of too is that insurance companies, who are typically the people who pay the awards that are awarded at a trial, or the settlements that are agreed to at a mediation, are aware that most people don't want to be, aren't willing participants in a trial and don't want to participate in a trial. So sometimes they use that feature at a mediation to make an offer where it might be sort of in the low end of the range, but still reasonable, knowing that you'd prefer to avoid that, and you want to make sure that you're not sort of taken advantage of in that way. Make sure that the outcome at a mediation represents a fair outcome based on what's expected at a trial. So those are just to sum up again, it's a long-winded answer to a short question, was what's the biggest difference? Biggest difference is you're the decision maker, not a jury or a judge, and the amount of time that it takes.
Perfect. Thanks, Joe. The next question is on fees. It's, do you as a lawyer get 30% of your medical allowance benefit when the insurance settles, or just 30% of the lawsuit settlement?
Yeah, so different lawyers work different ways. So we don't charge anything for the ongoing administration of the accident benefits claim. We do charge a percentage of the outcome. So in Ontario, since there were some changes to the no-fault claim, most people in Ontario have $65,000 of insurance that's available to them in the accident benefits claim. And what we typically find is that invariably our clients need all of those benefits and use all of those benefits. So it's only in the most significant cases where you have catastrophic claims and therefore access to $1 million, is it typical for us to issue an account on the accident benefits side. And typically that would be at a percentage that would be lower than what we would charge in the tort claim. The reason for that is because in a tort claim, if you're familiar with it, there are three different things that the defendants pay at the conclusion of a tort claim, whether that's at a trial or at an agreed upon settlement. So you get an amount for your damages and interest. You get an amount for the disbursements that the lawyer has paid on your behalf, and you get an amount for costs. So at our firm, the way that we charge is we charge a percentage of the damages and interest. The costs amount goes to the client, so we don't charge any percentage of that, and that goes to help offset the legal fee that we charge. And the disbursements come to us because we fund all of the disbursements on behalf of our clients. And in a typical case, our disbursements that we pay in a file are going to be somewhere in the range of $40,000. And I think the number that I heard in terms of the contingency fee was in the range of 30%. 30% is common sort of basis in terms of what a lawyer will charge on a contingency fee basis. Some are higher, some are lower. Again, what you want to make sure is that the costs are going to you to help offset that percentage. So, for example, in that 10% that goes to pay costs, which is the traditional rule of thumb in Ontario, helps to reduce that fee. So in most cases, it should reduce that fee from the 30% to something more like 20% of the damages and interest once you factor in costs. So hopefully that answers the question.
Thanks, Joe. The next question is, can you complain about poor treatment by a lawyer?
Yeah, you can and you should. You absolutely should. So as just like I said that we act for clients who have been harmed by professional negligence, that's true of lawyers as well too. So we have a supervising body, which is called the Law Society of Ontario. And much like your family physician or any physician who's governed by the College of Physicians and Surgeons, which is usually the one that people are most familiar with in terms of an oversight body, the Law Society of Ontario, which oversees lawyers in the province of Ontario, investigates complaints about lawyers and takes them very seriously. And they investigate every complaint that is made, and they report a finding to you, and they can issue disciplinary action against the lawyer if they believe that's the case. The other option that you have, if you don't want to go through the process of filing a complaint with the Law Society of Ontario about your own lawyer, maybe you're uncomfortable about that. It's a difficult situation to be in. I can't imagine being in that situation myself. And the other thing you can do is you can go and consult another lawyer about taking over your case. So in a personal injury world in the province, it's very common that I'll meet with people who have hired another lawyer and they're not happy with the progress in their case, or they're not happy with the relationship that they made with the other lawyer. Again, this is, the cases go on for a long time, and you have to have a good fit. You have to be confident that your lawyer is assisting you to the best possible outcome. So inside, you simply want to end the relationship with your current lawyer and move to another lawyer who you won't have those types of problems with. And we always get questions and concerns about that because, again, you're working on a contingency fee. You think you're going to have to pay twice. That's not how it works. Just because you committed to a contingency fee arrangement with an initial lawyer does not mean that you're stuck with that agreement and stuck with that lawyer if they end up you can consult with another lawyer. And if, again, the way that we work at our practice is if you decide you want to change lawyers, then we would deal with the previous account of your lawyer. We still wouldn't ask you to pay anything up front. You wouldn't have an obligation to pay their legal bill until the conclusion of your case. So it's important to know that you have options, and particularly if you feel the need to complain about someone in our profession, there are those avenues that you can pursue. So I'm sorry to hear you had that experience.
There's two questions from this person, and I'm not sure if they're meant to go together. So I'm going to read them both, and then let you decipher. So the first part is, if you get a settlement, does all the money go to the LTD insurance company? And the second part is, can your LTD insurance company threaten to stop payments for not completing an IME in their time frame if you aren't able to? Can LTD
All right.
insurers threaten to stop the payment?
All right. So I think these questions are probably where, Heather, the situation that you're describing is one where you have an accident benefit or an auto claim that's interfacing with your private benefits, your workplace benefits, or your long-term disability benefits, which is there is an interaction with these different types of claims as well. And so the question is, does all the settlement from an LTD insurance company go, or from a settlement go to the LTD insurance company? I can't think of any situation in my practice where that's happened. There are two situations where an LTD insurer has a right to reclaim some money that I can think of from another claim that you may have a right. So maybe you're injured in a slip and fall. Maybe you're injured other than in an auto insurance accident in Ontario, and then your long-term disability insurer has what's called a right of subrogation, meaning they paid you the benefits, but you were injured as a result of someone else's negligence. There's probably a section of the policy that says they get to have a step into your shoes and reclaim the money they've paid you back. But it would be very unusual, in my experience, that the LTD insurer would get all of the money from your settlement. And to tie into Heather's second question here, which is about the LTD benefits stopping if you're not completing your IME within a reasonable time frame. So again, this is pretty specific, but if the timing is now during COVID, I would say the answer is no. So you do have with your LTD insurance company, because it's your own insurer, you have an obligation to cooperate with them. It's not like a lawsuit where the same type of examination is through a defense medical examination where the outcome is not contingent upon your attending these, but where it's your own insurance company, like through a long-term disability insurance policy, or where it's through the accident benefits insurance company, you do have an obligation to cooperate with your insurance company in terms of adjusting the file, in terms of determining if you meet the criteria to claim the benefits in the first place. Now, there are a number of conditions upon those situations. They can't be unreasonable in terms of the timing of those requests. They can't repeat the same assessments on too frequently. They can't send you to an assessor who has no specialty in a particular area if that's what they're trying to assess. And if so long as you're being compliant in terms of trying to attend, no, I don't think that they can terminate simply because you weren't available on the first date. Now, if they've offered you a whole number of dates over a 6-month period and you can't meet any of them, then that may give them a basis. But just like you have an obligation to cooperate with them, they have a duty to treat you with the utmost good faith, which means that if you have a reasonable explanation for why you can't attend, then they have to consider that. And if they stop your benefit because of it, then again, it's a contract of insurance. So you can sue them to enforce the payment of the benefits if they improperly terminated your benefits because you didn't participate in an assessment. And this is something that comes up very frequently, quite honestly, during COVID, where maybe somebody doesn't feel comfortable attending an in-person assessment. So the question becomes, well, can we do it virtually like this? And the answer is yes, many assessments can be done virtually. So here, the insurance company needs to be working with you or with your lawyer, whoever's assisting you on the file, to be considering the various options before they cut you off. The short answer is yes, they can. The longer answer is yes, they can, but there may be consequences of their doing so.
Great. The next question here, Joe, is if you can speak to surveillance.
Yeah, so this is a question that comes up in every case. You know, it's if you're injured, the last thing you want is to have people following you around. And people think of surveillance, I think generally speaking, again, maybe because of dramatizations, people think, oh, these surveillance people are covert and I'm not going to know what's going on, and they're following me around with a pen camera or a pocket camera or something like that. In fact, almost every client who I've worked with where the insurance company is doing some surveillance of them is well aware that it is happening, because they don't always make it a secret of the fact that they're doing it. When it comes to surveillance, so we talk to all our clients at the outset of cases. Unfortunately, if you're in a public place, the insurance companies are able to conduct surveillance of you. What we say about surveillance is you only really need to be worried about surveillance if you're doing something that you say in your examination for discovery, or you say in your case, or you say to a medical professional that you can't be doing. And the reality is that most surveillance is a snapshot in time. It doesn't represent what your day-to-day life looks like. Okay, so maybe they caught you where on a frame where it's like tonight, so there's lots of snow, and you picked up a shovel and you thought, okay, tonight's night I'm going to give it a try, right? And maybe you managed to get through a quarter of the sidewalk or a quarter of the driveway, and then you call it quits, right? So then they've got the surveillance of you trying to shovel some snow, and you said, well, I have difficulty with it, or not. Well, what about this surveillance? Well, of course, they don't know that you spent tomorrow because you pushed yourself, or you were in physical pain after you did it. So what we do with surveillance is we try and contextualize it within the broader scope of our clients' presentation and limitations. But yeah, it's an unfortunate factor of cases that many people feel is invasive, and I can understand why. These days, we actually see less and less surveillance because, particularly with young people, so many people post every aspect of their life online, whether it's Instagram or something else.
Okay, thanks, Joe. The next question is, I'm covered by WSIB and receiving pay. However, my symptoms are getting worse through treatment instead of better. My union feels as long as I'm getting paid, things are fine. Is there a way to fight for better treatment?
Yeah, I mean, because if you're in the WSIB system, then you do have access to benefits through that system, which help with your rehabilitation needs. And if your union rep is not going to assist you with that, I would take the time and talk to a WSIB lawyer. I don't practice WSIB myself, but there are good WSIB lawyers who do that work in Waterloo-Wellington area, and certainly I'd be happy to send that name along if you want to follow up with me. And again, for the most part, they would answer those questions without any charge in terms of an initial consultation, help you get access to that rehab. The other thing you could do is if you're interested, Google the lawyer referral service at the Law Society of Ontario, and what they will do is the Law Society will put you in touch with a lawyer who practices in WSIB law, and by virtue of the fact that they participate in what's called this lawyer referral service, that lawyer has made a promise basically to give you an amount of their time free of charge, and they can take you through the issues that you're having. And you can decide if you want them to work on your case. So that's another resource if you don't have anybody else to reach out to who can advocate on your behalf.
Perfect. So the next question is, how often does a mild traumatic brain injury reach CAT designation?
Yeah, so it's a really good question. The statistics in terms of catastrophic injury designation in Ontario, I'm not as familiar with for 2021, of course, because we just started, but by definition, there's a very small segment of the population that meets a catastrophic designation. However, we have quite a few clients who sustained a mild traumatic brain injury that reached the catastrophic designation, it's really, really important to look at the individual aspects of every case to answer this question correctly. So how often depends entirely on whether or not your lawyer is getting the underlying assessments done to determine whether or not you meet a catastrophic designation. So if you're familiar enough with a catastrophic designation, you probably know that this is there's a legal definition that is met based on your medical diagnoses. And catastrophic designation takes place at various times over the life of your file. In order to make an application for a catastrophic designation, you need certain medical evidence, certain medical opinion, therefore. And so we regularly at our firm work with either your treatment team, if those treatment providers can do so, but also with experts in catastrophic designation, whom we basically regularly send them your file, ask them to review how you're functioning on a daily basis. Are you back to work? What are your current limitations? What are your current diagnoses? Are you going to meet that designation? And we have had some really good success in terms of achieving a catastrophic designation for mild traumatic brain injured people, because they unfortunately are just so impaired in terms of what they can do on a day-to-day basis. You know, it's called mild traumatic brain injury. That's the diagnosis. But as I sort of said or alluded to at the beginning of our discussion today, you know, just because that's the diagnosis doesn't mean it doesn't impact every aspect of your life. And that's what the catastrophic designation is meant to assist with, where you have a really sustained impairment in what you're able to do in most spheres of your life on a regular basis. So there's no sort of number that I can give you, but the way to be sure that the right things are being done in your case to decide if you meet the catastrophic designation is to get an opinion from the people who do that kind of work as to whether or not you may in fact meet a catastrophic designation. And your lawyer should know how to get that. So hopefully that answers the question there.
The next is more of a comment from Donna here, but I'm going to share it just in case anybody hasn't seen it. So she's just speaking to a really extreme example of surveillance. And she says, I was first surveilled outside my house, and then the next day they followed me to Sable Beach and stayed on vacation with me and my family for 4 days. Creepy.
That is very, very creepy. So this is, again, I think the clients that we work for, the people who are sort of find the surveillance the most invasive, have real injuries and are trying to just get back to their normal life as much as possible. And the people who are, you know, I think like Donna here, are the most frustrated by it is because it's affecting their family, right? There's no reason why, you know, you need to involve, like I have young children. If someone's surveilling my 5-year-old daughter and my 3-year-old son, I would be very, very angry about that, and rightfully so. I had actually one case where they did a lot of surveillance of our client, an awful lot of surveillance of our client, and they sent it over and they thought they had the smoking gun, so to speak. And I sent it over to our client. We had a discussion about it, and then we had a good laugh because they had surveilled her mother instead of her. They just happened to look alike.
Oh, that's funny.
I think there's a follow-up too there, Mara, that where I've got the chat open now here. So it says,
yeah.
Can they get into your social media even if it is set to private? So the answer is no, they can't get into it. The legal test, though, if you have a lawsuit or an arbitration, what we're seeing in these types of cases is that the judges are ordering you to make your social media profile available, even if it's private. It has a lot to do, if the judge will order it, has a lot to do with how you use that social media, what kind of things you post on it. But the short answer is, unfortunately, they can gain access to your social media profile, even if it's private. So I think that takes us through the questions. And and also through the time that we have. I mean, I can answer any, if people do have any questions that they didn't get in, please feel free to put in the chat or take yourself on mute. I can flip over and dance through these slides quickly, but I do feel that we covered it all off. And what I can do is I can share the slides with you, Donna, or with Linda, and then if people have any other questions that they want to get through, then we can certainly address that maybe at another time.